Hey, good morning, everybody. Today's a special day for us. We have Matt Triani here. He's our, what are you, Chief Legal Counsel? What is your title over
I have
there?
the longest title. It's Vice President of Professional Development and Chief Counsel, and I don't know, probably some other things too.
That's awesome. As we all know, there's been a lot of changes with Nvar with our contracts. We've asked Matt to come and talk to us about that, and he's also going to talk a little bit about some of the things that we're seeing on that he's hearing on the legal hotline.
Mm-hmm.
And this is one of my favorite trainings every time when we get Matt to come in. And I'll give it a minute too, because I think you want to introduce one of your new attorneys, right?
Absolutely.
Thank
you.
I'll let you take it away.
Oh, thank you very much for the invitation and the opportunity. I'm going to welcome up to the stage, so to speak. Maria Flax is a new attorney here at NVAR. Maria's been with us for about 6 weeks now.
Yeah.
Right? Time flies. So we're actually really, really fortunate as a local association. There are 1,100 local realtor associations in the country. Almost none of them have one attorney, much less two. But what that does is that it enables us to be able to do a lot of things. Sorry, we're getting a little bit of an echo, I think. We're able to have a comprehensive standard forms library. That's something that would actually be very difficult to do without any attorneys, but it's much easier to do with two. The legal hotline, I know many of you use that. You're going to be talking with Maria quite a bit, but we're incredibly excited to have her on board.
Thank you, Matt. I'm very excited to be here and to meet you guys, and to those who I haven't met yet, I'm sure we'll speak soon. My name is Maria Flax. A little bit about myself. I went to college at University of Maryland in College Park. I went to law school at UNC, Chapel Hill, and I've been an attorney for about 8 years. Prior to this, I was in litigation, so I was working for a couple of firms doing defense work. And I decided that I wanted to do something a little bit more, proactive, a little bit more before there's any conflict. So that's why this opportunity came up, and I decided to jump on it. And I'm very excited to be here, and I think NVAR has a lot of good services for you guys. So yeah, I'm very happy to be here, and I'm excited to meet all of you.
And we're super excited to have her on board, and I've said it a million times, but nobody's more excited than me as well, because I was doing two people's jobs there for several months. So incredibly excited to have her on board. She's going to be an awesome addition to the team.
Thank you.
So cool. All right, so what are we here to talk about today? Standard forms updates. Now, one of the nice parts about this presentation is that I can actually cover a lot of legal hotline FAQs and standard forms changes at the same time. Because we hope that you all find the legal hotline to be an invaluable resource to keep up to date on things, get questions answered. But on the same time, it's an amazing resource for us. Because if we see the same questions coming up over and over again, well then, maybe we need to enhance our education or our communications on the issue. Or maybe there's a way where we can clarify something within the forms. And so you're actually going to see a lot of the January 1 forms changes were reflective of questions that we were getting over and over again on the hotline. So, jumping right in. Believe it or not, it's actually not just myself and Maria just sitting around all day trying to figure out ways to make your lives more difficult. We actually have a standard forms committee that is comprised of your fellow realtors. We actually expanded it this year. The standard forms committee every year is one of the most popular committees that everybody wants to sign up for. Which meant that, there would be 70, 80 people exhibit interest, and I could only take 16. That's a lot of people to say no to. But there's also a lot of work to be done, so we actually expanded the Standard Forms Committee to 20 this year. And a couple of your fellow Samson agents are actually on the committee as well, so we're very excited to have them on board. We had our first meeting of the year yesterday, and we are already off to a great start. So it's the only committee or volunteer group in the association that meets more than the board of directors. We're very proud of that. A couple of other things, though, that I hope that you all take away from this is that we basically make forms updates for two reasons. Sometimes the law changes. Okay, so we're going to make sure that the forms are always compliant with changes in the law, whether it's a court case or the legislature does something interesting down in Richmond. But also, we want to make sure that they are useful to you all. We are very cognizant that these forms are used by non-attorneys. They are used by realtors and their consumer clients. We want to have forms that are actually clear, concise, let's reduce some of the legalese. It is a legal document. There is some that's unavoidable, but we want to make sure that these are documents that you can use without necessarily having to have a law degree or have to call us up every single time that you're filling one out. Are there situations where it comes up where, yes, you need a question answered? Sure, that's what we're here for. But our guiding light is, how can we make this clear? How can we make this easier to use? We're very proud of the fact I've been with NVAR for about 4.5 years, and we have shaved 4 pages off of the contract. So we are down to 12. Try to get this thing down to 10 if we can. So what did we do here for the January 1 release? We actually went through and revisited the standard, the residential sales contract, which is our core form, really. It is our most frequently used form. Because we want to go back and we want to ask the question, why? We don't want to just make these little like piecemeal changes here and there. We wanted to do a wholesale review. We started from the beginning paragraph and went all the way through the form. Some of this is to try to improve the form itself, but part of this, I'm also going to give you all a little bit of a sneak peek of where we're going. In the next year or two, our goal is to actually reduce the number of forms that are available in the forms library. Rather than having a individual form or addendum for every single situation, every contingency, every clause, we would actually like to have a core group of forms that are exactly where we want them to be, and then have a much more comprehensive clauses library that you can plug in as appropriate into the transaction. So that's going to be a shift. We're not just going to do it overnight. It's going to be it's something that we're going to be building on here for the next couple of years. But that is our goal, is to go back and revisit the core group of forms, the sales contract, the lease, the brokerage agreements, get those to be where we want them to be, and then have a much broader range of clauses that can be used to supplement or modify those core group of forms so that your contracts just reflect only what you need, nothing more, nothing less. So that's why we've gone back and we've done this. That's a really long way of saying is that we've made some very fundamental and systemic changes to the sales contract this time around. You all probably have seen that, hopefully. You can always visit or view our forms changes on our website. If you go under Law and Ethics, Standard Forms and Revisions, every single time we make a change, usually it's twice a year, July 1, January 1, go there in June and December. We publish the changes and educational versions of the forms about a month before they go live. So you can actually preview them before they go live. And of course, I know you all are on SkySlope, and SkySlope gets all of the forms as well, well in advance so that there aren't any hiccups. We also do videos, not just the one that we're doing here, but we do Legal Minute videos, we do blog posts, we do social media, we do webinars. So there really, hopefully, isn't any excuse not to be able to keep up to date on all of these things. So, sales contract, what are we doing here? Let's start with the opening paragraph. The opening paragraph of the sales contract included some information that we felt was actually pretty unnecessary. So up until January 1, if under cooperating brokerage, it said cooperating brokerage represents, and then there was a checkbox, seller or buyer. Well, sub-agency has been illegal in Virginia since 2012. So there aren't any situations in Virginia in which the cooperating brokerage represents the seller. You either have the cooperating brokerage is the same as the listing brokerage and you have a dual or designated agency situation, but they're still representing the buyer. They're not representing just the seller in that scenario. So we remove the checkbox. Listing brokerage represents seller, cooperating brokerage represents buyer. If there is no cooperating brokerage, then you can put none or NA. I know that does sometimes happen these days, but the bottom line is that nobody is representing the seller because there is no sub-agency. There's also there was some language in the sales contract right up front that talked about dual or designated agency. Well, dual or designated agency already has a legally required disclosure, and it has to be addressed in the brokerage agreement. What business does this have being in a contract between a buyer and a seller? It's not relevant. We're assuming that the parties have already done what they were supposed to do by addressing it in the brokerage agreement and in the disclosures. The brokerage is not a signatory to the residential sales contract. Yes, there's information about the brokerage in there, but we've already better handled these things elsewhere. There's no reason to be repetitive and say the same things over and over again. So paragraph 2. We did a little bit of reformatting. We seem to tweak this a little bit every year. We want to make it more user-friendly. You'll see that we actually put the sales price right up at the top now. That's a really important detail. Let's get that right out of the way up front. We also clarified, because we want the form to be useful in a variety of different types of transactions, and it seems to me, based off of what I'm hearing in the marketplace, that cash is king, and cash transactions are becoming more and more common. Therefore, we wanted to clarify, how do you fill this out if there's no financing? Well, you put 100% of the sales price in the down payment section. We have that in parentheses now. It's a little bit more guidance. We didn't really make any other changes to the financing piece. We had already changed that up a couple of years ago. We feel that's in a pretty good place. But we did, yet again, try to clarify what we mean by seller subsidy. I don't know, for whatever reason, there seems to be some confusion. Some sellers apparently think that, you know, it's a subsidy to them. So we have put in parentheses now that this reduces the net to the seller. I don't know how much more succinct or clear we can get on that, but I'm sure we'll probably revisit it at one point or another. But a couple of the other changes that we made to paragraph 2. So paragraph 2E, you've probably noticed that we've tried to make sure that we can put as much relevant information on the first page of the contract as we can. A couple of years ago, we updated it to make sure that whether or not the transaction is contingent on financing is on page 1. So that is still there, but we made a couple of minor tweaks to that too. It used to say that if the contract is contingent on financing, there were 3 things that had to occur or that were responsibilities of the parties. It said that the buyer has to apply for the loan and any lender-required insurance within 7 days, gives permission to the lender and the cooperating brokerage to provide general information and updates about the loan. Those are still there, but there was a third piece, and it said, and the seller will comply with reasonable lender requirements. Well, here's the thing, folks. If the buyer is obtaining financing, whether or not the contract is contingent on said financing, the seller's going to have to sign some documents at closing, and they need to accept that. We've actually already addressed it in the title paragraph. The title paragraph says the seller is going to sign such documents, affidavits, and things in order to facilitate the transaction. So we don't need to say it again or make it appear that it only applies where there is a financing contingency. Buyer's getting financing, even without a contingency. Seller, you're going to have to sign some documents at closing. Don't sit there and complain at the closing table. You're actually going to potentially create a default situation. Let's just be clear. Let's move on. So we struck that. So now we have a new paragraph 2F. We're trying to get as much information as possible on the front page of the contract. Now we say whether or not the contract is contingent on appraisal on page 1. Contract is or is not contingent on appraisal, checkbox. But something else that we've done that's very, very fundamental, and this is probably the biggest sea change in the contract, is we got rid of the old paragraph 11. You all are probably familiar with the old paragraph 11 was a general access to property paragraph. It said seller will provide reasonable access to buyer's representatives, inspectors, appraisers, etc., to comply with the contract. Now, believe it or not, those words, to comply with contract, was actually really meaningful. A lot of people would miss out on that. They would think, oh, well, you just got to provide access. Well, no, our intention in using that language was to say that if you did not have a contingency, then the seller did not have to provide access. If you did not have a home inspection contingency, the seller does not have to provide access for the purposes of a home inspection. If you did not have a finance or appraisal contingency, the seller did not have to provide access for financing or for an appraisal. Well, part of that, everything I was talking about earlier about trying to make the contract more specific and less legalese, that's just a very broad, ambiguous statement. So we thought, well, how about instead of having just this general access paragraph, let's go to every portion of the contract and identify when is access necessary. And then let's get the parties on the same page right up front. Rather than arguing about access 7 days, 10 days, 21 days into the contract, let's be very explicit. Let's get the parties on the same page as of ratification. So the first place that we have that is in paragraph 2F. If the contract is contingent on financing or appraisal, seller will provide access to the appraiser. Simple, tells the story. If it is not contingent upon financing and or appraisal, now we've got a checkbox, seller will or will not. Let's make sure that we negotiate this up front. We do understand that in this market it has been harder to get contracts ratified with a financing or appraisal contingency. If the buyer is willing to take that risk and not have the protection of a contingency, they're free to do so. But the bottom line is that if they're getting financing, they still need to have a appraisal done most of the time. So for us, this is an educational moment, that if you are representing a buyer that is going to be waiving financing or appraisal, they need to be talking to their lender prior to ratification and saying, hey, are we going to need an appraisal on this? And if so, then you do not ratify a contract where it's seller will not provide access. You make sure that you ratify contracts that says the seller will provide access. But what we're doing is forcing the contract to the forefront. I see Mr. Briggs has a question.
Your eyes are good. Well, this is big, everybody. It's good that it's in bold and it's right at the bottom of the page, so it's kind of hard to miss. But you don't want to miss that, whether you're a listing agent or a buyer agent. I suppose if they say it's not if the buyer agent says it's not contingent on financing, listing agent has a decision to make as to whether or not to clarify on that. I'm in favor of checking one or the other. That's what the boxes are for.
Absolutely. Now,
you don't have to leave it blank.
You don't have to check them if you have the contingency, of course. But if there are no contingencies, absolutely check a box.
Matt, can you speak to FHA and VA, or do you want to hold that for
that's going to be an
hotline?
FAQ, I think, toward the end, because it's just a little bit of a teaser, a preview, is that FHA and VA, as many of you probably know, have certain appraisal protections that are baked in. These are required by federal law. They supersede anything that we put in our contract. Now, the Standard Forms Committee tried to rack their brain on this issue for over a year, and ultimately came down to the point where we realized that we could not create an elegant solution to it in the forms themselves, that this is an educational issue. Let's talk about a specific situation that sometimes comes up. The buyer writes a contract that is contingent upon conventional, or there's no financing or appraisal contingency at all. And then 2 or 3 weeks later, suddenly the listing agent gets a request from an appraiser to come in and do a VA appraisal. Okay. I think it's fairly clear that when you change the type of loan, you lose the protection of the financing contingency. That is clear under the contract. The buyer does not have the opportunity to void under the financing contingency if they switch from conventional to VA, or if they never had a financing contingency to begin with. However, most of you are probably familiar with the VA notice of value and the FHA amendatory clause. These are documents that you will frequently sign as a part of the loan package, or maybe even prior to closing. And it's something that is included in our VA and FHA financing contingencies. Basically what they say, paraphrasing here, the buyer cannot suffer any penalty, such as forfeiture of earnest money deposit, or be forced to go to closing in the event that the appraised value of the property is less than the sales price. That is federal law. It applies regardless of whether or not the borrower has negotiated that contingency up front. There's very little that we can do about that as a matter of contract. Until they've clarified it at the federal level, then that is what we are going with. I have been reaching out to our litigator friends in the legal community for the last several years to see if we have any court cases on it. We have not seen anything yet, but I have a really hard time believing that a Virginia court would say that a veteran is not entitled to some benefit that they've earned by virtue of their service. So I think it's just something to be aware of, that even if it's not negotiated up front, if the borrower ends up using VA or FHA, they are going to essentially have a backdoor appraisal contingency. Best practice probably for the seller or the listing agent in that scenario is to allow for the appraisal and hope it comes in which case then there's not an issue. If it does come back and it's a little bit low, then you try to do your best to negotiate it, because otherwise I think that the buyer's probably going to be able to exercise their ability to void the contract. So, is the mic on? I just want to make sure we can hear you. We want to make sure everybody, I can hear you. We want to make sure everybody watching at home or elsewhere can hear you.
Our broker said, don't leave blank without checking box, either or. You're saying if I happen to wrote the contract non-contingent, then contingent, then I don't have to check box seller where. I was taught to always check one way or another.
Check boxes are incredibly important, and I always say go with what your broker says. But
Right.
at the end of the day, it's if you have checked the box that it is contingent on financing or appraisal, we are very, very clear about this, that access is to be provided. So you don't have to check either of those. I certainly would not want you to have the contract contingent upon financing or appraisal and then check seller will not provide access, because that's just going to create a ton of confusion. But if you want to make sure that you're quite literally in this situation, pun intended, checking all the boxes, you could check will. That would be consistent.
Right. Okay. Another question was that you say if, for instance, conventional financing switch to VA or FHA, before you switch, my understanding up until now, you must have agreed upon, otherwise you're just losing out your financing contingency totally if they don't agree.
So this is where we start getting into the Truth in Lending Act, which is a federal statute. The buyer has the absolute right to choose who they want to work with and what lending options they would like to pursue. What we have created in our contract is potential penalties if they change from what they've originally represented. At the end of the day, unless the buyer is actually trying to exercise the financing or appraisal contingency, it does not matter what loan program they use. If the buyer shows up at closing, as long as they are providing legal tender, then it's none of the seller's business where that money comes from, because they have not defaulted. The only issue that comes up is when the buyer is trying to take advantage of a financing contingency. Our contract says that unless the buyer has agreed to a separate financing contingency with the seller, and why would the seller ever agree to that? I don't know. Maybe you all can tell me if that's ever happened in your experience where you started as conventional and then the buyer wanted to switch and the seller actually agreed to a new financing contingency. I'm sure maybe it's happened. I can't imagine it happens often. The buyer does lose the protection of the financing contingency, but they're not in breach of the contract. They don't have to get the seller's permission to change, only if they wanted the continued protection of the financing contingency. Does that make sense? Okay.
Point out, correct me if I'm wrong, but buyer can waive financing contingency under FHA and VA.
Yes.
You can waive the financing qualification part, right?
Exactly.
It's just that FHA mandatory clause or Virginia VA statement of value is going to come up. We do have situations where there's discussions about that document being provided at the settlement table, late in the game, not right up front. But it sounds like you said you've worked for a year trying to get some language in here that explains to the party that, call it what you want, it's still effectively, it is contingent on the appraisal.
Absolutely. And I mean, we could just come outright and say that, but we also are hoping that maybe we might get a little bit more guidance from a court before we establish that standard, because one of the things that we also balance on the Standard Forms Committee is how frequently something is happening. And if it's something where we call it the 90-10 rule, is that if, we try to address things that are coming up so frequently that they're impacting transactions at least 90% of the time. If, it's something that just does not happen that frequently, sometimes by actually trying to address something like that, we draw attention to it in the contract, and then everybody starts getting bright ideas. So that's actually part of the reason why we decided to hesitate on that, is that if we came outright and said that, basically if this is regardless of a contingency, VA or FHA is not applicable and you can't waive it, then I think you're going to have a lot more people taking advantage of that.
And those paragraphs are not in the residential sales contract, correct? They're on the financing addendums.
Exactly. We've tried to carve out everything separately as to only if it's relevant where it's contingent on financing. If you don't have a financing contingency, then the specified financing doesn't really matter.
See, and I don't want to belabor this, but if the buyer and the buyer agent check no, this contract's not contingent, and yet they state that it's FHA or VA, and they don't include an addendum, that's assuming that the listing agent and the seller are expected to know.
Yep.
And that's not good. I mean, yeah, experienced agents should know that. Listing agents should know about the amendatory clause and the VA statement of value, but what if they don't? I mean, is that a license law requirement that they are aware of that? And the seller certainly doesn't know it. And so the buyer has made a representation that there's no financing contingency, and yet they can then later come back and declare the contract void when the appraisal comes in low.
There's a lot of areas where I think the federal law has a lot of work to do when it comes to these programs. Another one that comes to mind is that you all are probably familiar with, right? The National Association of Realtors is currently subject to an antitrust lawsuit by the Department of Justice. And part of that is wrapped up in the notion of cooperative compensation, that the buyer buyer agency compensation via the listing brokerage is somehow is potentially an antitrust issue from their perspective. And okay, my response to that is, well, I think you're wrong on the law and the facts. But secondly is that, so what you are essentially saying is that veteran borrowers are not entitled to representation? Because VA borrowers are not allowed to pay a cent for compensation for their own representation. So if on the one hand, the Department of Justice is taking the position that buyers should be paying for their own compensation, but then you've got a VA underwriting standards say that the buyer can't pay it. So okay, veterans, you're on your own. Good luck. Now, I come from a big military family. I don't think that that's anybody's intent. But, you know, that's why it's really important for people to think these things through. I do think that it is a big education issue, and we will continue to promote it. We actually have a legal hotline FAQ on this on our website addressing this very issue, and I wish I had a clear answer. But right now, I think the two biggest takeaways are, number one, financing and appraisal are separate. Okay? So you can not have the benefit of a financing contingency by changing the specified financing. However, if you are switching to VA or FHA, chances are you are still going to have some kind of appraisal protection, even if you did not negotiate a appraisal contingency up front.
NAR is working on it, right?
They are, absolutely.
With Veterans Administration or DOJ.
Absolutely.
Because what we've seen, the classic example recently in the last 2 years is the buyer wants the property, they want VA, they're willing to pay X amount over a low appraisal. And they write that in, right? Well, what's a listing agent to do in advising their seller?
Well, and so that's a really interesting area too that we're gonna address a little bit when I talk about why we got rid of the other provisions section, because of these very scenarios. So most lenders tell us that a VA or FHA borrower can agree up front to say they will pay up to X. They can't write a blank check. They can't say up front that they will make up any difference between the appraised value and the sales price, but that it is enforceable as a matter of contract for you to be able to say that you will pay up to a defined amount in the event of a low appraisal. But if you're going to do that, you need to make sure that you're agreeing to that after the financing and appraisal contingency in the contract. Because if you put it beforehand, it's a standard principle of contract interpretation that if you have two clauses that are not consistent with one another, whichever one is agreed to last is going to control. And so if you are going to modify that appraisal standard, say you have an appraisal contingency, and it says the buyer cannot waive their protection, they have the absolute right to void in the event of a low appraisal, then if you're going to agree to make up the difference, that should be the absolute last thing that you sign in the contract. Even if we're just talking a matter of 30 seconds where you're going in the order of documents, making sure that
prior to ratification. But prior to ratification, not after. It's part of the deal from the get-go.
Oh yes, it's part of the deal, but what I'm suggesting is that instead of having it in the body of the residential sales contract, because that's usually the thing that's signed first, and then 30 seconds later you sign the financing and appraisal contingency, if you want to modify that appraisal contingency, then you should have a separate addendum after that. Signed almost contemporaneously, but it still has to be signed in order of the documents.
This is big. Thank you for this. I don't know if you all agree with me, but what he's saying is we can override that inherent conflict that we've dealt with so many times, the contradiction between what was being written in to other terms and now would be on an addendum about the buyer saying, here's proof of funds, I'm willing to pay $25,000 or $50,000 over any low appraisal. I
want to hang out with who you're rolling with.
That can supersede, around here, some of the people using the VA on these high-ticket properties, right?
Sure.
But that will supersede that language in the amendatory clause. I mean, you've got
until we hear otherwise from a court case, we have been told by the lending community that will hold up.
Excellent.
So I think we have a question online.
Yes, it's from the other half of Kratz and Kolash. Can you clarify what is the assumption if there is not an appraisal contingency and neither box is checked for access?
I would say that you got some clarifying to do. So here's the thing, a contract is a meeting of the minds. Now, does that mean that you have to agree to absolutely everything? No, but it is a meeting of the minds, an agreement as to all material terms of the contract. I'd say whether or not there is an appraisal contingency is actually a very material term to the contract. So if you haven't checked neither box, there is actually a pretty good question as to whether or not you're even ratified to begin with. So go back and fix that before you proceed further. That's like you put on that you haven't agreed to the sales price, or you haven't agreed to the earnest money deposit, or a, settlement date or something like that. Those are all really material terms. If you haven't spelled those out, you're still negotiating.
I think a clarification on that question is, if in the appraisal contingency you do have checked is not contingent, but you don't have checked will or will not provide access.
I think that the presumption would be in that scenario. I mean, it's always helpful to clarify. I would say let's be as thorough as we can in double checking our contracts before we consider them ratified. But in that scenario, I think that since we have previously stated that if it is contingent, seller will provide access. If you check not contingent and you don't check either of the access boxes, the presumption is that access is not granted. It's a deductive reasoning. It's an inversion of the logic. If there's contingent, then there is access. Well, if it's not contingent, the presumption is there is no access. Does that make sense? Okay. As much as possible, let's try to be clear. I do know that sometimes we add these additional terms, but they really are there to try to empower you all to make sure the parties understand what it is they're getting into, so you're not having this conversation with your clients 3 weeks into a transaction when all of a sudden the listing agent gets an appraisal access request and the seller's like, what? Why, where did that come from? This isn't contingent. So, all right. Moving right along. So 2G, we added in, we moved that up. That used to be, I think, paragraph 15, so we haven't changed that a whole lot. Paragraph 3, though, this is another major change. Probably the two biggest changes we've made in the sales contract governs access, and here is what happens with the earnest money deposit. First of all, we made some technical corrections to it. Again, we want to try to remove non-contractual language. The contract is between the buyer and the seller. Let's focus on what their rights and obligations are. We used to have all this language in there about, well, if the escrow agent is a VREB licensee, then this is what they have to do. And if it's a settlement agent, then this is what they have to do. Well, the law applies regardless of what we put in the contract. When you put it in the contract, you give the appearance that it's negotiable. It's not. So we simply say the escrow agent will deposit the EMD in accordance with applicable state and federal law. Boom, hey, we just cut off 4 lines. This is how we get things down to 12 pages, by the way. But the more important thing, I think, here is that up until now, the seller has not had a timely remedy if the buyer has failed to deliver the earnest money deposit on time. Now, I do hear from some people that they say, well, the earnest money deposit is the consideration for the contract, so we're not ratified if they haven't delivered it. That's not correct as a matter of Virginia law. Virginia law is quite clear, and our contract is quite clear, that the parties' mutual promises to perform is the consideration necessary to form the contract. You can have a legally enforceable contract with 0 as the EMD. I'm not saying it's a good idea. I'm just saying that it's possible. But what is also clear is that if the buyer has failed to deliver the earnest money deposit and the escrow agent in time, buyer's in default. That is a breach of the contract. Now, up until January 1, the seller basically had to wait, though. The buyer's in breach of the contract, but but the buyer can also cure that breach at any time by just going and delivering the EMD. If the buyer showed up and delivered the EMD in a reasonable amount of time, then the seller hasn't really suffered any damages. If you miss the deadline and then you notify the buyer and they're like, oh, my bad, and they go and deliver it the next day, what harm has the seller suffered? The buyer has cured that breach. But what happens when the buyer delays? In an environment where buyers are having a harder time getting contracts accepted with contingencies in place that provide protection for them, some buyers, probably a little bit less risk averse than I am, were willing to roll the dice to say, hey, you know what, I'll ratify this contract, but I'm never going to deliver the earnest money deposit, and I'll decide whether or not I want to show up at closing, and I'll just dare the seller to sue me. Nobody's going to sue anybody over $3,000. That's just the reality of it. So what was happening, though, is that you've got a seller that's in a bind. The buyer has not done something that is a significant obligation of ours, but the contract is still live. Now, the seller can say that, hey, it's been a week, you're refusing to do it, I'm declaring you in material breach. You can't enforce the contract against me now, so I'm not going to provide you access. I'm not going to show up for closing. You want me to do any of those things, deliver the EMD. But now what happens is now you're dragging this out 30, 45, 60 days, right? And the seller is essentially waiting for the buyer to show up at closing or not before then they can go and take action. Well, we realized that's an unsatisfactory remedy. And so we went back and took a look at this and we said, okay, now the seller has the ability, in the event that the buyer has not done what they said they were going to do and delivered the EMD on time, the seller now has the ability to void the contract straight away. Now, I want to be very, very clear on this. If the seller has voided the contract, they are admitting they no longer have a claim for damages against the buyer. They're just cutting their losses. They're saying, look, it's been 5, 6, 7 days, it's been off the market. Maybe I've got some backups, or maybe there was some other interest in the property. This buyer clearly is not serious, so I'm just going to void and I'm going to move on to the next thing. As remember, our contract says if the contract has been voided, the parties are going to sign a release and walk away. But that's a business decision for the seller to make. They can, and remember, this is just optional, they can give the buyer additional time. Say, hey, buyer, I'm going to give you 2 days to get this delivered, otherwise I'm going to void. Or they could decide, you know what, I really want to go after this son of a gun for damages, so I'm going to wait. They have that option, but we are now providing a more timely remedy that if they feel that the buyer's not serious, has not done what they're going to do, the seller can simply deliver a notice to void and walk away from the contract and move on.
Did you and the Standard Forms Committee seriously consider building in a cure, like 2 days?
We did.
Or
We
a
talked
blank, a blank line so that, because this is we're going to have a lot of situations with this one, obviously, right? And
we went back and forth
I thought
on this.
personally, I thought that would have been a better way to have, because you have lots of options in our contracts. Seller has the right to say, you got 48 hours to get that EMD in, and if you don't, the contract's void.
We did consider it. In fact, I drafted language to that effect. The Standard Forms Committee ultimately debated this for a couple of months and came around and said, you know what? We want clear, bright line rules as much as possible. The seller always can exercise their discretion as to how they wish to approach this, but the bottom line is that the buyer failed to do something that they said that they were going to do, and there are consequences for that. You're going to see when we talk a little bit more, when we get into like the title paragraph and the time is of the essence paragraph. We have time is of the essence on our contract. What that means essentially, that's a fancy lawyer way of saying when we say a deadline, we mean it. So let's stop having all of these carve-outs for all of that. If the parties want to give one another additional time in order to keep the transaction going, great, they have that discretion. But we want to be clear that when we say that there's a deadline in the contract, we mean it. Let's stop having all of these carve-outs. Let's let the party address it on a case-by-case
Unlike
basis.
other contracts in the Commonwealth of Virginia, like CVR MLS and I think Virginia Realtors.
Yes.
Everybody, there's some of you that use that contract when you head down south a little bit.
Could you all imagine on or about?
That's what they have. They don't have hard and fast.
So so prior to coming to NVAR, I worked for a national title company based out of New York. I did transactions in 37 states. And we're a little bit unique here. I think some of it is the Wet Settlement Act. The Wet Settlement Act is very rare. There's only one other state that I'm aware of that has it. That's Arizona. What the Wet Settlement Act means is that in most transactions where there's a federally related mortgage loan involved in the transaction, the settlement company cannot disperse until after they've recorded the deed and deed of trust. And they have to do so within 2 business days. Most other states are escrow states. The parties sign, they get the money in place, and then they just say, okay, today's the day. We break escrow, that's it. We are much more explicit about that. Some of it is the law, but some of it is also just the pace of the way things move up here. Hey, if things are different downstate, that's fine. But around here, we've got a very sophisticated, fast-moving market with educated consumers. They don't want well, so when exactly are we closing? They want to know when they want to know as much as possible when they're closing, not just an on or about kind of thing. So what we're essentially doing is just taking that time is of the essence idea and just applying it more broadly in other areas of the contract.
Matt, one more, sorry. With the release of contract form, when the EMD has not been delivered, I get that one.
Yep.
Because there's confusion amongst the agents as to whether it should say the EMD, that you fill that into the form, that it's going to be released even though it was never delivered to escrow. Any comment on that?
This is a really important area to understand, is that the release is not just about the EMD. The release accomplishes two things. Yes, if the earnest money deposit has been delivered, then it clearly directs the escrow agent to disperse the EMD accordingly. But you'll notice now in the void paragraph, we say that the parties will sign a release including the earnest money deposit, if any. So we try to clarify that because there might not be one. The whole point is the seller's voided because it wasn't delivered. But then the second piece is actually the parties' mutual agreement not to sue one another. Can a void contract, if you voided a contract, it is dead, it is nullified, it's no longer in effect. The release is what kind of wraps it up in a neat and tidy bow. Now you've got something in writing, the parties have agreed not to sue one another. And so the release is still important in that scenario. All I would do is, if the earnest money deposit was never delivered to the escrow agent, is just either leave it blank or NA or something, just for the EMD section. The rest of the release language is still actually pretty important. I would encourage you all to do that just so that it is clear you got the party's signature that they're not going to go after one another afterward. So it's an important point. Yes?
So in the review department, we just wanted to make sure that we were 100% clear. So when you have, when you say there's no longer a claim for damages from the seller, does that mean for sure if the EMD was never delivered that the seller cannot, they're not entitled
only if the
to
seller
receiving?
voids. Only if the seller voids.
So in this case, when they release the contract, there's going to be no situation in which the seller would receive the money.
Exactly.
Okay.
And that's a business decision the seller needs to make, and it is an important distinction. The seller, if they choose to void, they're saying, look, we don't feel good about this. We don't feel comfortable about proceeding with this buyer. Let's cut our losses. Let's take it back up. Let's get back on the market, whatever the case may be. But we're not going to pursue them for any dollar amounts. That's why it's the seller's ability to make that choice. They don't have to. They really want to stick it to the buyer for whatever reason, or maybe it's a big EMD amount and they're willing to, it's a $25,000 earnest money deposit and they're willing to keep the property off of the market for, for 30, 45 days. They can do so. Although, again, in that scenario, you're not doing like an action against the escrow agent. You're actually suing them for damages. So that's something that the seller has to determine as a business decision. Yes?
What's the avenue for the listing agent and or seller to be notified that it has not been deposited? There's nothing in here that says they're required to be notified in any way. Mm-hmm. And of course, if you go and check, you've put the company on notice who's immediately going to call the buyer's agent and let them know to deposit it.
That's correct. And the thing is that you have to understand is the escrow agent is not a signatory to our contract, which means that there's only so much that we can do to spell out what they can or can't or will not do. But I think that it is a best practice for a listing agent to have a reminder on the calendar that, hey, this was the delivery date. I'm going to go follow up with the escrow agent, find out whether or not it's been delivered. If the escrow agent notifies the buyer and or the buyer's agent, that's great because that's still kind of accomplishing what you're trying to achieve here, right? So that the seller has not necessarily voided yet. But if the buyer turns around quickly and delivers that EMD, then hey, everything's great. They've cured the default. Seller no longer has the ability to void in that scenario, and the contract will proceed. But if you do find out, you alert the escrow agent by asking whether or not it's been delivered, and then they say no, and you basically go and you go into SkySlope, you type up a notice to void, send it to your client, you get it over there within a few minutes. Chances are you're going to be beating the buyer to the punch, and that contract's going to be void. So, there is a little bit of a race kind of aspect to this. Who can get to the post first? But I still think that it is a best practice to follow up on these deadlines, the same you would on anything else.
It's an ethical obligation and even a license obligation for a listing agent to advise the seller. I think they got to advise the seller if they become aware that the EMD has not been delivered.
So ultimately, obviously, Mike, you know better than anybody that it's ultimately up to your fellow realtors and a grievance or professional standards committee to determine code of ethics violations. But knowingly withholding that kind of information from your seller, I think, would probably be an ethical violation. And I can tell you that DPOR has absolutely taken the position that not taking reasonable efforts to notify your client or ensure that deposits are delivered in a timely manner is considered a state law violation.
Everybody get that? Yep. That's buyer agent and listing agent.
Exactly. In my opinion, it is a little bit of a stretch of the VREB regulations for DPOR to take that position, but the law is what the judge says it is. So, and they've taken that position, so I wouldn't mess around with it. This has been on their radar. Basically, the feedback that I've gotten is the buyer's agent has the obligation to do everything short of kidnapping and forcing them to sign a check in order to get that EMD in on time. So, okay, moving right along. So that's paragraph 3. Paragraph 4. We're getting there, guys. There's only like 20 some odd more, right? It's going to pick up a little bit. These are pretty foundational things. Paragraph 4, we made a couple of important tweaks to this. Number 1, we've clarified, this is the settlement paragraph. We have clarified, consistent with Virginia law, there is one settlement agent. There is one settlement agent and they are chosen by the buyer. That is the law. Let's not be confused about this at all. Now, does that mean, because I know everybody loves to do those split settlements. When I first got in the settlement biz about 10 years ago, I'd say about 85% of the closings occurred with both parties at the table at the same time. I heard now it's basically inverted. It's about 15% of the time. Does that mean that the seller cannot sign elsewhere? Of course not. The seller's obligation under the contract is to sign documents and deliver them as well as any necessary funds to the settlement agent by the end of the settlement date. That is their obligation under the contract. Where the seller chooses to do that is actually the seller's business because we cannot control that. Now, if you are representing a seller and you are doing a split, I would recommend that you notify the settlement agent and preferably the buyer's agent sooner rather than later for 2 reasons. Number 1 is that I don't know how many of you all have paid attention to this, but when you send a contract over to the settlement agent sends out a letter to the parties. Usually it's by email. And what it does is it says, we are so-and-so. You all are affiliated with Cardinal. So Cardinal Title, these are the services that we provide, and these is what we charge for our services. Let us know if you have any questions. If you do not notify the settlement agent that you're going to be that some other entity, whether it's a law firm or another settlement agency, is going to be requesting payoffs, preparing the deed, and whatnot. If you do not notify them, then the settlement agent can go and start doing the work because that's their job. And if they actually perform those services, they are legally entitled to charge the seller for those services rendered. So if you do not want the seller to receive duplicative charges, you need to notify the settlement agent sooner rather than later if they're going to be doing any of the work elsewhere. Otherwise, the settlement agent could double charge them. Okay? And then the other second important piece of this is I said that the seller has to deliver the documents by the end of the settlement date. Time is of the essence. If you are signing elsewhere, you need to sign early. And those 2 entities, the law firm or the settlement agent that the seller is signing with, and the actual settlement agent have to do some coordination. They have documents to share, deeds to be prepared, and things that have to be drawn up. They need to get all of those issues addressed sooner rather than later. That way, it can be delivered to the other company a few days in advance. The seller comes in and signs, and then they can overnight it back to the settlement agent. Getting it to the settlement agent the day after the settlement date is breach by the seller. So if you want to do split settlements and you're representing the seller, you want to keep your seller out of breach, get all of this stuff done early. I think I'm preaching to the choir here on this one. It looks like you have a comment.
Very good advice.
So, and that's part of the reason why we also moved the performance paragraph up into the settlement paragraph, because performance is settlement. It's delivering the documents and the money to the settlement agent on time.
And if it's a split, the parties are not going to be at the table together anyway. Mm-hmm. And so why not have your seller go in the day before?
Get it
Or-
done.
or
I
couple
would
days
make an
couple days
argument that if you do not get the documents and or funds to the settlement agent selected by the buyer by close of business, that the seller is in breach of the contract.
And I guarantee you Cardinal staff will endorse this, right? They're
I know-
applauding right now.
I know. I was going to say I know several of them, and I think we're all on the same page on that one. Settlement is defined by Virginia law. This is not something that's a creature of contract.
Matt, I think this is actually one that I called in and spoke to your esteemed colleague here, and I also spoke to Laura Farley down at Virginia Association on whether or not the seller has the unilateral right to go somewhere else once the contract is ratified, just like the buyer does.
Yep.
Right? The buyer does too. It's really clearly spelled out that the buyer can do it under RESA and RESPA or whatever. But it doesn't say that specifically.
And-
it does say buyer selects or designates the
And the buyer
settlement
can
agent.
change their mind too, as long as it doesn't delay settlement. The buyer could, theoretically change their mind. I'm not encouraging anybody to do that necessarily, but the buyer can change their mind post-ratification, and they can deliver a notice. It's not an addendum. As long as it doesn't cause a delay in settlement or the seller suffers damages as a result, then the buyer can do that. It's a little bit murkier on the seller side. There is guidance from the Bureau of Insurance related to RESA, the Real Estate Settlement Agents Act. There's guidance from the federal government regarding RESPA, the Real Estate Settlements Procedures Act. And there's also legal ethics opinions from the Virginia State Bar. The seller, there's no question under the Virginia and federal constitution that anybody is entitled to legal representation. So there's nothing that we could put in the contract that would prohibit the seller from going to a lawyer or law firm to achieve those things. It's a little bit murkier when you're talking about a lay settlement agent. But if you're just going to another settlement agency to get the documents notarized, request a payoff, and things like that, you can do that. And I don't think that it's a contractual provision so long as the seller is not in breach. We looked into trying to provide language on this that would kind of facilitate split settlements and things like that in the contract. And the Standard Forms Committee and the Attorney Roundtable ultimately came back and said, number one, it's too complicated because we're getting conflicting advice. And number two, it's not necessary and it's just going to draw more unwanted attention to the issue. At the end of the day, I think that a seller could simply say is that we are going to perform our settlement obligations elsewhere. Do it sooner rather than later.
Every settlement or title agency, title company, still has to have an attorney prepare the deed.
Absolutely.
Right?
Absolutely. It's actually Virginia law that unless the parties are preparing the deed themselves, the Virginia lawyer even has to have their name, address, and Virginia State Bar number on the deed. That's been in effect for about 6-7 years. So it is incredibly important. All I can say as a matter of guidance is we know that there is one settlement agent. We know that the seller still has closing obligations that they have to get in by a certain amount of time, and we know that it is incumbent upon the seller to make these arrangements sooner rather than later. So until we actually are, we have some attorneys that are affiliates of the association who are currently trying to work on a new updated legal ethics opinion that might give a little bit more guidance on this. But it has not yet been approved. So as soon as we have more guidance, you all will be among the first to know. This is one that keeps us up at night. So, all right. So, and like I said, we moved the performance paragraph up into paragraph 4 since performance is essentially settlement. Let's see, paragraph 6, we just made a couple of little tweaks. We removed reference to delivery for Virginia Real Estate, or the Virginia Residential Property Disclosure Act. That's just a tweak because there isn't anything in the statute that defines how delivery is to be made. So we can write it into the contract. Paragraph 7, speaking of the Virginia Residential Property Disclosure Act, one of the things that we have been trying to do in the contract is to remove non-contractual language. Like I said, putting in things that this is what the law is makes it appear that it's negotiable. You all might have seen about almost 2 years ago, we made an update to the POA and Condo Act sections where we basically took out, each one of them had like 4 paragraphs where it was like, the Act further provides, and the Act further provides, and all of these things. The bottom line is that the law is what the law is. Now, we can have more information about that. We created an understanding your rights and obligations under those acts that is not an addendum to the contract, it's just a consumer informational piece. But we just were able to shorten it by just including the language that is required by the statute. Now, we've tried to do the same thing here with the Virginia Residential Property Disclosure Act. We have a hyperlink to the statute, and it simply summarizes what the parties' rights and obligations are. And another thing that enabled us to make this change is that the law requires that a buyer sign that one-page residential property disclosure acknowledgement form, the DPOR form, the one-pager. Buyer has to sign it, and they have signed it saying they've been informed of their rights and obligations. Why are we trying to do it all over again? There's no need to reinvent the wheel. It's already been addressed as a matter of state law. So we were able to shave another paragraph off the contract there too.
Not to sidetrack, but could you give us the top 3 or 4 examples of clear exemptions from seller's
Yes.
responsibility?
So the most common ones are, of course, if it's being sold by the government or a governmental entity. If there is there are no improvements on the property, it's really just raw land. It is not required. The biggest exemption is that it has to actually have a residence on it. Commercial property, unimproved land are not applied. And then the third most common situation where it's exempt from the statute is where it is the transfer is being done by a trustee or a fiduciary of a trust, an estate, foreclosure, that kind of thing. But otherwise, remember, this is also just a disclosure that discloses almost nothing. It's just it's like, hey buyer, this is all the stuff that we're not telling you about. Go do your homework. So, and most of the time in those scenarios, the people aren't going to have any knowledge or information to disclose anyway. So
No downside in citing it.
exactly.
Right?
And in abundance of caution, just sign it, because they're literally just telling the buyer, hey, by the way, I'm not going to let you do an inspection, but go do an inspection. All right, so that brings us, actually, speaking of inspections, a nice little segue there to paragraph 10. Remember, I talked earlier about how we got rid of the general access paragraph. So now we're trying to address situations on access for the purposes of verifying the physical anymore. Simply, it is not contingent upon a home inspection, but in this scenario, the seller will provide access.
Listing agents, do your job, right? Look at that very carefully. Last night I got a question from an agent. It's the first time she'd seen this new contract. She was the listing agent, and the buyer agent wrote in there this timeline, which was effectively till settlement.
That's pretty smart.
And
I like
I'm glad
that.
she asked. she reached out, and I was like, I wouldn't. I mean, ask your seller.
That's like going back to, you remember back pre-2015 when we had that three-day notice period, and we had home inspections that were running all the way up until settlement? I don't miss those days. That was crazy. Final walkthroughs were still part of the home inspection contingency, basically. It was crazy. We've tried to reduce that
Much better.
We've tried to reduce that by having clear deadlines, right? That's why we shifted to a negotiation and buyer election period. So at the very least, we have a clear end date for when these things are to be resolved by. So yes, but yeah, it's incredibly important to still pay attention to these details. These really do matter. And we try to be as explicit about these as we can, but it still really is incumbent upon you all to make sure that the contract reflects your mutual understanding.
And with everybody doing digital signature, it is so easy to whip through these offers and not catch stuff. So slow down a little bit.
There we go. I mean, remember, we're talking about, and I know that you all do this all the time, and everything is moving very, very quickly. Your clients are expecting a quick turnaround. The other side is demanding that you get the offer over and all of these things. But we're talking about a major investment. For your clients, this is probably the largest investment they're ever going to make. Most people are only going to do 2 or 3 transactions in their entire lifetime. You owe it to them to take an extra few minutes and make sure that you're dotting your I's and crossing your T's. Okay, soapbox down. So the other piece that we try to address is final walkthrough inspection, because we have been getting some feedback that some buyers are using it as basically a whole new home inspection. That is not the intent behind a final walkthrough. The final walkthrough is there for the buyer to make sure that the property is in substantially the same condition as the date specified in paragraph 10 at settlement. That the appliances work, that there isn't a tree in the living room, that there's not a foot of water in the basement. Okay? It is not an opportunity for a whole new inspection. So you will see that the only parties to which the seller has to provide access for the final walkthrough are buyer and broker. That's it. We are not including contractors, inspectors, and things like that. Now, there is a disclaimer to this that we're going to get to when we talk about the inspection contingency removal addendum. In the very limited scenario where the seller has agreed to perform repairs on the inspection contingency removal addendum, in that scenario, the seller, the buyer may bring in an inspector if they wish. They're not required to, but in that scenario, the board felt very strongly about that, but we created the default rule that it's just buyer and broker to start. Okay? All right. So moving right along, possession. Two things that we've done in the possession paragraph. Number one is we added mailbox keys. I didn't really realize that was such a big deal. So we clarified that in addition to garage door openers, key fobs, keys, mailbox keys, if any, shall be conveyed at settlement. Okay. Again, it's if any. Sometimes in investment properties, we all know the seller may not have the tenant lost the mailbox keys or whatever. Sorry, buyer, you just bought a $500,000 property. You have to go down and spend $20 at the post office to get a key made. Sorry. Well, and half a day while you're at it too. So, we have tried to clarify that issue. The second thing that we've tried to clarify is what the seller's responsibilities are in conveying if smart home appliances convey. We're going to discuss that a little bit more in paragraph 13 because I think this is a really important thing. If your sellers have like the digital Honeywell, or they have like a Ring doorbell, or any of those smart home appliances that are attached to a fixture that they want to take with them, they should uninstall them prior to ratification. Okay? Because otherwise, if they are installed as of the date on paragraph 10, they are going to convey. So they should uninstall them if they want them to go. But if they do convey, say that it is connected to the HVAC unit, or it's connected to the fridge or the alarm system or whatever, and it's conveying, that we're saying here is the seller must deliver exclusive control over those features at settlement. Okay, now again, this is anecdotal. I don't know how much it's happening, but this is why the contract gets longer all the time, is because people do things that I would have never thought before, and we're like, now we have to have a form for it. We had some sellers who were really bent out of shape at settlement for whatever reason. Maybe there were some last-minute negotiations they weren't really happy about, and so post-settlement, they still have the thing on their smart device, and they start messing with the thermostat or the alarm system in the middle of the night to just mess with the buyer. You cannot make this stuff up, seriously. So I would argue that that's actually also trespass, and so that there are issues there, but we've also made it abundantly clear that it's a potential breach of contract to do that too. Restore it to factory default settings, or just uninstall it from your phone or your smart device or whatever. Just sellers, let it go. It's not your property anymore. A couple other things we did in paragraph 13. So we've clarified that smart home devices, if installed, will convey. And then we also removed all those no check boxes on there. It was such a simple thing that we hadn't thought of before, but it said, if checked yes below, these things are installed and offered and will convey. Okay, well then why do we have a bunch of no check boxes? Just leave it blank. So we got rid of those. We've done the same thing on the listing agreements and on the optional listing information sheet. It's just easier, save you all a little bit of time. Check yes if it applies. If not, leave it blank. It's just the little things that improve quality of life, right?
Matt, so in paragraph 13 for everybody, it speaks to the smart home devices as installed, but it doesn't list anything like a Ring camera or anything else in the section with all the check boxes. So, buyer agents, have your eyes on. Talk to your buyers, make notes when you're touring the property, because if your buyer wants that stuff conveyed, clarify it.
Absolutely. It's the contract is a framework for you all to work within. At the end of the day, it's still your knowledge, it's still your expertise, it's still your attention to detail as specific to those individual transactions that's going to carry the day. We're just trying to provide a framework to facilitate the transaction.
I should have said listing agents, because they are going to convey. It's written that they will convey, so it's the listing agents. And we had this recently where a seller took some surveillance cameras off. They were mounted on the garage and around the property and stuff, and they took them.
Yep.
After settlement, the buyer's like, "Where's the cameras?" You know.
Oh, I mean, it's even like really picky and stuff. You know, I've had people take the batteries out of the smoke detectors on the way out. I'm like, are you kidding me? That's, first of all, it's a violation of state law. But secondly, all right, I just spent several $100,000 on your property and you're taking 30 cents worth of batteries with you? I mean, come on. But people do crazy things. You know, you all see it more than I do. So I think Cece's got something.
Let's say you have a doorbell camera. Do I have to mention that at all?
Nope, if it's installed, it conveys.
So.
Yeah,
but
I mean,
it's-
if they
it's
don't
a-
want it to convey, they should either uninstall it before you ratify,
Right.
or you'll see below, we have a do not convey section now too.
Yeah, but we don't have the electronic anything. It's written in the yes conveyance.
So it's just in the general paragraph above.
Right.
It says these things automatically convey.
Now, the listing agent has to be peg on that. Have to leave it. That's all.
And a lot of the reason why we made these changes to the forms too is to just draw more attention to the issue, right? Just to make sure that you're thinking of these things. Sometimes we put things into the forms just to make sure that you're having the conversation with your client, to make sure everybody's on the same page. But yeah, I mean, sometimes people get really bent out of shape on this stuff. It's just amazing to me. Some buyer's trying to blow up a $750,000 deal over an $80 Honeywell, smart device. I'm like, really? I would offer sometimes at the settlement table. I'm like, hey, we're just going to knock this off of our settlement fee. This is getting ridiculous. Just to get the deal done. The other things that we added, I mentioned that we added a does not convey section there, so you can be specific about that. The other thing we also try to address is other conveyances. So we were hearing more and more that, say that you've got a property where the seller doesn't want to move the pool table or some exercise or playground equipment, or maybe there's like some gardening equipment in the garage or something like that. The seller doesn't want to take with them, they're willing to leave. Well, the lenders were getting really bent out of shape about, the appraisers were trying to figure out whether or not they had to back the value out of those items out of the appraisal, and it was creating some issues. So we reached out to our partners in the lending community and we said, this is the issue, this is what we think is a proposed solution, can you provide us some feedback? And this is the language that they gave us, is that as long as it's in there that it is as is, it's for the seller's convenience, and it's for no additional consideration, that's going to keep the lenders happy, and you're not going to have to worry about doing like separate bills of sale or anything like that. You can just get it taken care of right there in the contract. So try to make things simpler.
Even if it's a Corvette or whatever.
Yeah, just you got to make sure that they think that it's a beater. It's a 72. It needs a lot of work, right? Once you start getting into some of that, you might want to consider a bill of sale, because at that point it is going to be for some consideration, and you're going to have to actually transfer the title to the vet anyway too. So
That was a great addition.
So
Really was.
it was something that was brought to the attention by some of the brokers that have been experiencing this on the forms committee, and then we reached out to 5 lenders that we work with, and we said, hey, can you run this by your toughest underwriter to make sure this is going to meet muster? So, all right, so let's see what else we have coming up. Yes.
Just a quick question. For fixtures and the walls, for example, wall mounts for the TVs and such, are those supposed to be left behind? And if they are removed, is the seller supposed to fix the holes on the walls, etc.?
Excellent question. So we changed this in 2019. We specified that that the mounts themselves convey unless otherwise specified. And the reason why we did that was for that very issue, is because what was happening was that there was some disagreement over whether or not the mounts stayed in place, but the buyers were taking the mounts and they're leaving these like gaping holes in the wall, and the seller's frustrated. So we said, hey, you know what, let's create a default rule. The mounts stay put. If the seller wants to bring them with them, then they can negotiate that with the buyer about, okay, yeah, you also have to patch and paint. So that's why we addressed that, is to force the conversation. But the default rule is the wall mounts themselves will convey with the property. They're going to stay, but the seller can take the TV unless they want to leave it.
Same concept with the window treatment hardware.
Yes.
Exactly, right?
I never realized I would get so many questions about window treatments. I had
Sorry.
people like fighting over these like $30 1978 Kmart curtains and things like that. I mean, it's just absolutely ridiculous. But the window treatment hardware stays. Anything that's mounted or affixed into the window or the wall stays. Window treatments
That's not
is
the
the
rods,
soft
though,
stuff.
right? Not necessarily the.
Not the rod, because you
Not
can take
the
the rod
rod.
out. Usually you could unscrew it and go. So, but when we talk about the window treatments for the purposes of the check boxes, we're talking about the rod, we're talking about the drapes, we're talking about the shade, anything that's not physically installed. Yes? People do weird things. I mean, it's again like, are you going to take these things with you and use them in your next house? I mean, they're 40 years old. But okay, fine. Yeah, if that's what you want to do. You got some emotional attachment to a curtain rod. Maybe we'll throw in an extra couple $100 and you can go get some therapy or something. I don't know. Yes.
I just want to understand in paragraph 13 that the distinguishing difference between surface-mounted electronic component devices and smart home devices seems to be the dividing point of whether it conveys or doesn't convey. Mm-hmm. Which brings to question a smart TV or something like that, which is a surface-mounted electronic, but is not a smart home device.
Well,
Where's the dividing line?
The distinction is that it's the smart devices are defined as something that is connected to a fixture that is conveying. That's the distinction. Is that so? A smart TV can be removed and still work on its own. It's not hardwired into anything that is necessary. It's not hardwired in an HVAC unit or alarm system or something that is staying with the property. It's not a fixture because it can be so easily removed. Smart home appliances are those kinds of electronic components, but they are attached or affixed to and only operate in conjunction with a fixture that is conveying with the property. So. My smart TV can work anywhere that I can connect to Wi-Fi. I can take it out of the wall and take it with me. My Honeywell doesn't do anything unless it's connected to an HVAC unit.
What about a Ring doorbell?
I would argue that the Ring doorbell is something that should convey. I think we could be a little bit clearer on that piece, but I think that it should convey. The bottom line is that if the seller wants to take it, uninstall it.
Yeah, I just see a lot of confusion that could come out of this in distinguishing which one
we
is
always
which.
learn too. I mean, what we do is we put our best effort forward on defining these things, and then what happens is we hear things on the hotline and we say, okay, maybe we can tweak this. I mean, we try to be as flexible as possible because I'll be honest. This is one of the interesting things about I've learned over the years about writing contracts is there's always going to be somebody who's going to come up with something that like it just doesn't neatly fit into what you've done, and you can't write a contract that's going to be perfect for everything. It has to be specific enough to be enforceable in virtually all cases, but flexible enough that it's actually going to be useful to you all in a variety of scenarios. There's an art to that, and we don't always get it 100% right, but what you do have our commitment is to be responsive to it as it evolves.
And the does not convey addition helps, right? I mean, that's new.
Specify it in there.
That's new. It's good. Use it.
If the doorbell doesn't convey, then camera of doorbell doesn't convey, then they have to replace their regular doorbell.
Not necessarily.
There's no doorbell?
Doorbell's not legally required to have it. I mean, you probably don't want to leave like a gaping hole in the door frame on the front door or something, but you don't necessarily have to. We don't have a checkbox or that kind of stuff. So you can write in Ring. The Ring doorbell does not convey. That's fine. At the end of the day, I mean, let's also just keep an eye on the big picture here. We're talking about several $100,000 deals. People getting bent out of shape on these things that are not that expensive. I mean, again, I know that people get an attachment to them. I mean, some people, I guess, love their Alexa or their Google Home or whatever, but okay. Got to keep moving on because I actually have a 1 o'clock that we have to get back to 4. So we will make it work, though. Default. Paragraph. So we removed some unnecessary language from the default paragraph. There was this provision in there that was inconsistent. Our default paragraph says that the party is in default, in addition to other damages, is actually responsible for paying the brokerage's fees if you all decide to pursue it. But then we had this other section that said the brokerage may accept 50% in exchange for a release. Well, you may accept 25%. You may accept 100%. You may do anything. Why is it in there? It's not really binding on anything. It's may. It's optional. So ultimately, at the end of the day, we put in the default rule. You all can pursue the commission if you would like against the party in breach, and we leave it up to you and the brokerage to figure out how much you want to pursue and whether it's worth pursuing. But that language was just not necessary. The title paragraph, another important change that we made here. So we tried to streamline it. I was talking about time is of the essence. We had a carve out there that if the seller was not able to provide marketable and insurable title by the settlement date, the contract continues, but the buyer can void at any time. Well, if we have putting all of these obligations on a buyer to do all of their things by the settlement date, why are we giving this like gaping loophole for the seller to continue on? If the buyer is willing to give the seller more time to clear title, then the parties can agree to extend the settlement date. But otherwise, the seller's in breach if they fail to do that. This is a really important part of their responsibilities under the contract. So you can adjust it on a case-by-case basis if you need to move the settlement date, but we've got a clear, defined end date of the contract. They have to deliver marketable and insurable title by settlement. The other thing that we changed, and this was just something that was really interesting to me, is that the contract used to say that the title may be subject to commonly acceptable easements, covenants, and restrictions affecting the property as of date of settlement. So what that means is, say that the seller was really close to their neighbor, and they get under contract and they're like, hey, how would you like to have an easement across my property? I want to do you a solid before I sell this thing. Under our contract, they could have done that. They could have unilaterally recorded an easement post-ratification that affects the buyer's interest in the property without being in breach. We have now clarified that title is going to be subject to easements, covenants, and restrictions affecting the property on date of ratification. If the seller wants to change the scope of the title after that, they have to go get the buyer's permission. Okay? A couple of other things. We had like a miscellaneous paragraph. We just, instead of having 15 different headings, we just put a bunch of like miscellaneous boilerplate stuff together in the paragraphs. Wood destroying insect inspection. Again, we addressed the access piece on that. The seller is going to provide reasonable access to buyer, broker, and inspectors to do the WDI. And then we also clarified, because for some reason we kept getting questions about, well, if there aren't any live insects, do they still have to, repair or remediate? And whatever the report says is what the seller has agreed to do. So we've clarified it's and or. So live destroying wood destroying insects and or damage or evidence of previous infestation. So we're covering all of our bases. Let's see. I think the
Sorry, if the report says there was evidence of infestation, but it doesn't say that they see live bugs, and the report, which they always do, recommends treatment.
Mm-hmm. Seller still has to do
Seller
it.
treats.
Yep. And the thing is that if you're concerned about this, particularly if the seller has had prior experience or maybe they have a service plan or something like that. I mean, again, we're not talking about big dollar bills. Just to have this seller at seller's expense, and they can bring their own company in to go and deliver the report. We're not talking about major dollars. I think the most expensive a WDI inspection I've ever seen was like 80 or 90 bucks. No, I'm not talking about the treatment. I'm talking about the inspection. So that's the big thing is that, look, if the seller's really going to be concerned about the buyer bringing in somebody that's going to make them do a bunch of unwanted things, then they should check seller at seller's expense on the contract. It's probably going to save them time and aggravation. The other thing that we, I think, will wrap up the sales contract, and we have a couple of other minor changes to the forms. The other thing that we have is that we've eliminated the other provisions section. I touched on this earlier. Okay. Now, there are two main reasons why we got rid of other provisions. Number one is that I think that it encourages you all to pretend to be lawyers. It incentivizes you to want to draft legally significant language that may or may not be clear and may contradict other aspects of the contract as written. It also helped us get to 12 pages, so I think that was worth it anyway. But it doesn't mean that you're not without remedy. I do understand that there are situations where you need specific additional provisions that you want to put in the contract. But like we talked about earlier in the appraisal scenario, the best place to put that in is put it in the blank sales addendum and have that be the last thing the parties sign at ratification. Okay, because what that's going to do is that's going to make sure that it's clear that it is modifying any other terms that come prior to that. So it's not like you're without a remedy, it's just that I've seen so much junk put in that other provision section over the years that we just felt that it was very important to kind of nip that one in the bud.
Paragraph 30, time is of the essence.
Yes.
Removal
Of TRID.
Yes.
So like I said, we're trying to get rid of all those carve-outs, right? We say time is of the essence. That means that we mean our deadlines. But then in the actual time is of the essence paragraph, we had a carve-out. That's kind of ironic. So I think it was very well intended. You know, if you all remember, if you were in the business way back in 2015, 2016, everybody was very worried that the truth in lending RESPA integrated disclosure rule was going to cause all kinds of delays in settlement. You know, those 3 days that you had to deliver, even though technically speaking, that was always the law. Regulation X always required 3-day prior disclosure. They just decided never to enforce it up until then. Everybody was worried it was going to delay settlement. And so we put in a carve-out that said if the delay in settlement is caused because of the lender's compliance with the TRID rule, then the buyer is not in default, but the seller may void at any time. Well, honestly, we've just found that it doesn't really come up very often. It hasn't been an issue. It hasn't been an issue for years. If the buyer is not settling on time due to an issue with the lender, it usually has nothing to do with TRID. It's either the lender didn't get the job done on time or the buyer wasn't providing the information necessary. That's got nothing to do with TRID. That is actual potential default. So we just got rid of that. You know, if the seller is willing to give the buyer an extra couple of days, extend the settlement date, but it has nothing to do with TRID. Let's remove that confusion and an opportunity to argue over something. So I appreciate you reminding me of that one. I thought I almost forgot. I'm doing all this on the fly. Usually I have a slideshow.
Can you believe this guy? It's in his head. You've done this a few times.
A few times. Yeah. So what else have we updated? Well, we updated the home inspection and radon testing contingency. We did two things on that form. Number one is that we kept saying in every single contingency, if the utilities aren't in service, this is what happens. Or if you have failed to deliver the report or the notice to void on time, this is what happens. Well, why do we have to just keep restating that? So we just created a miscellaneous section that applies to all of them, shaved a half page off the form. The second thing that we did that was very intentional here is that we tried to better define what we mean by home inspection. Okay? Home inspection, and you see that it's S in parentheses, it's home inspections, is deliberately broad and flexible. There is a reason for that, and you all have probably experienced it. The buyer brings in a home inspector's looking around and says, well, you might want to bring in the plumber, you might want to bring in the electrician, might want to bring in the mold folks or the roofer or the structural engineer, or I never knew there was such a thing as a chimney expert until, in the last couple of years, but you might want to bring in the chimney expert to take a look at that. Home inspectors are generalists. They use more wiggle words than lawyers do these days, okay? And that's fine. But we want the buyer to be able, if the buyer can get those parties in before the deadline, then we want them to be able to do that. And most of the time, they're not going to discover that until the inspection has occurred. They're not going to know that at ratification who they want to bring in. So we want this to be more flexible. However, we want to be very, very clear that if we have a separate clause, contingency, or addendum for it, that's not part of the home inspection. Okay? We have separate clauses or contingencies for radon, for well testing, well inspection, and septic. Therefore, home inspections do not include radon, well testing, well inspection, or septic inspection. Okay? If you would like those, then you need to negotiate those separately. I think the most common scenario that I've been hearing about, at least, is that the home inspectors are a la carte, right? You go and your client signs up and they check the boxes and they're like, hey, while I'm at it, yeah, radon sounds great, but they haven't agreed to a radon testing contingency. Well, there's two major issues that I have with this. Number one is that the seller has not agreed to provide access to the radon tester to drop off or pick up that canister. So now the seller and the listing agent are ticked because they didn't agree to that up front. But number two, and I think more importantly, of what value is that test to the buyer? The reason why we have the radon testing contingency is it spells out the conditions in which the seller is contractually obligated to maintain the property to ensure a valid and accurate test. without a radon testing contingency, if the seller is really ticked and they find out that a canister was left during the home inspection, they can open up all the windows, they can come and go as they please. They can mess with the system. They can put a remediation system in right next to it that's pulling it out as it's coming in. That test is of no value to the buyer. That is a consumer protection issue as far as I'm concerned. So if you want to do that radon test, we are now being very, very clear. Negotiate the contingency. Otherwise, seller does not have to provide access. It is not part of the home inspection. Okay? Inspection contingency removal addendum. This is one I touched on a little bit earlier. I said that we talked about the final walkthrough inspection. You only have to provide access to buyer and broker. Well, we did hear from some members of the board of directors that they were concerned about certain situations where the seller has agreed to perform repairs. And the realtor did not want to be responsible for taking a look at those repairs and confirming that they were done. And so we have a very limited carve-out scenario in the inspection contingency removal addendum. If the seller has performed repairs on that addendum, then they will provide, in addition to buyer and broker, they will provide the inspector's access for the final walkthrough. If the buyer wants to pay for it and is willing to bring them back in. It's not a must. It's the buyer's option. I want to be very, very clear, though, that this does not change any of the parties' fundamental obligations under the contract. Okay, the seller is required to hire a licensed, if applicable, person to perform the work and provide receipts. That's the seller's obligation. This is not creating necessarily a window where the buyer can go back and say, I didn't like how you did it. It's literally just to protect the realtor from having to say whether or not it was actually done.
And it does not say that it has to be the same inspector.
It does not.
It could be a licensed contractor,
That's correct.
right? Does not have to be a
As
home
long as it's
inspector.
within their area of expertise, yes.
Yeah, but don't go on a fishing expedition.
It's
right
not
before
intended to be a
closing.
fishing expedition,
Yeah.
no. And this is another one that I think we're going to have to monitor. The board felt very strongly about this, but we'll keep an eye on it to see if there are any additional tweaks that are necessary. Also, the parties can always cross it out if they don't want to do that. You can always cross that piece out.
Matt, real quick, would you speak to post-settlement occupancy or vacancy inspection and how?
I'll
this
make it
doesn't
really, really short. Don't
yeah,
do them.
Yeah.
Don't do post-settlement
Don't
occupancies.
don't do rent back agreements. Right. If you're the listing agent or seller, don't do them. All right.
Don't do them. They're
Fair
a
enough.
nmear. I mean, I could do a whole class just on
But,
post-settlement
the buyer
occupancies.
owns the house, so they can have whoever they want.
Exactly.
in
It's the
house.
buyer's property. They have reasonable access to their property, okay? Again, I get it, especially buyers, they're trying to sweeten the deal. I don't recommend them. I think it causes a lot of confusion. We are going to be revisiting the post-settlement occupancy agreement this year on the Standard Forms Committee because I just think that there isn't any way to get the parties on the same page on this one. We hear over and over again, the buyer's trying to find some picky reason to keep the security deposit tied up. Or maybe they didn't do a final walkthrough, so they don't even know what the condition of the property was at settlement. There's just a series of cascading effects. The buyer is supposed to have insurance in place because the buyer is responsible for risk of loss, but the seller is responsible for maintenance. Well, how do you square those two? The best guidance I have on that is the seller is responsible for any damages caused by their negligence or intentional acts, but acts of God is the buyer's responsibility. Property floods through without seller's fault, or tree falls on the house, that's still the buyer's issue. It's not the seller's issue. If a appliance has reached the end of its natural life, the seller does not have to get the fridge died. The fridge died during the post-settlement occupancy. Seller doesn't owe the buyer a new fridge, okay? Unless they did something, they beat up the fridge or something like that, or they did something that caused it to collapse. No.
Same physical condition as of settlement.
This is another one of those areas where I think it's too legalistic and is requiring a legal interpretation to try to understand maintenance obligations versus risk of loss. And that's the best guidance I have is the seller's responsible for their negligence or intentional acts or that of their family members or agents such as movers. But acts of God, that's the buyer's liability. We're looking at revising it, but that is the legal interpretation of reading both of those things together. Or if you all would let me, I would just get rid of the darn thing because I think it's a terrible idea. Extend the settlement date if the seller wants to live there longer. Work it out financially.
Thank you, Matt.
I
got
just
two
have
more?
one more thing to talk about if we do have time. What time is it?
If you do.
Is it 12:30? Oh, we're gonna fly. It's gonna be great. Okay, we have an optional listing information sheet, right? Hopefully you all are aware of it. You're using it. It's a great way for a seller or listing agent to put information in front of the buyer's agent so they can write a clean offer the first time. We've also created a new form. It's an optional buyer offer cover sheet. Basically, it's a one-page cheat sheet. The listing agent can, comparing multiple offers, can see sales price, settlement date, whether or not there's post-settlement occupancy, what contingencies are in there. Now, we want to be very clear on this, that it does not substitute for the language in the contract. If there's any inconsistency between the cover sheet and the offer or the contract, offer or contract is going to control, okay? So you still have to do your homework. You don't just accept an offer blind, go back and read it, but this is going to give you the ability to easily kind of narrow down the field and then go and review the offer before you sign. The other thing that we've done with the optional information cover sheet is we've received some feedback from buyer's agents that they're concerned their offers are not getting presented. Now, there is nothing as a matter of contract or law we could do to force a seller to sign something that says that they've seen and rejected an offer, particularly in a scenario where you got multiple offers. Seller's not signing 20 of those things and sending it back. However, there is something under the Code of Ethics that empowers you all. Standard Practice 1-7 of the Code of Ethics says the buyer's agent has the ability to demand that the listing agent respond in writing to confirm that they've presented the offer or the seller's waived presentment. So we've included that in the offer cover sheet. You can, if the buyer's agent, when they submit that offer, they include the cover sheet and they check the box at the bottom, they are demanding that the seller respond to confirm that they've presented the offer or the seller's waived presentment. The listing agent can do that by simply responding by email. Yes, it has been presented or whatever, or they can sign and date at the bottom and return the offer cover sheet too.
The form calls for the signature. You're saying, I mean, in practical terms.
In practical
email,
terms,
yeah,
it's still
works.
going to be compliant, but what we're trying to do is facilitate this, make it easier for people. Because there's not a lot of visibility on this. I know we do have to jet, but thank you so much for the invitation, the opportunity to present.
Thank you very
It's always a
much.
pleasure.
Appreciate it, and thanks, guys. Thank you.
Hey, lots of good questions.